While there are other legal matters at the hour, the 50-50 split in the National Assembly's 400 seats has dominated proceedings into the constitutionality of the Electoral Amendment Act. One of the applicants, the Independent Candidates Association South Africa, has challenged the new system of representation. The Amended Act splits the 400 seats in the National Assembly in half, 200 regional seats, 200 compensatory seats. The council, on behalf of the ICA, has argued before the Apex Court that there is no justification for the 50-50 split, as it disadvantages independent candidates by increasing their quota to gain a seat in the National Assembly. Parliament, however, submits that it serves a legitimate purpose.
We've provided a fairly detailed explanation as to where it comes from, but for present purposes, if I could perhaps just underscore the following. The first is that the compensatory seats and the regional seats serve entirely different purposes. And the compensatory seats, it's common cause in this matter, and Mr. Atkins accepts, serve to protect against a distortion of proportionality. The second point is that it is accepted that on the 200-200 split, there is no risk of overhang.
Well, we're going to be joined via Teams by Advocate Paul Hoffman to unpack the arguments of the Independent Candidates Association of South Africa, One Movement South Africa and Rivonia Circle to have parts of the Electoral Amendment Act declared invalid and unconstitutional. On that note, a very good afternoon to you, Advocate Paul. Thank you for your time with us here on the SABC.
Good afternoon to you and to the SABC viewers as well. Thank you for the opportunity.
So we're trying to understand the merits of the case and what's at stake for the democracy of South Africa. Perhaps for context sake, you could talk to the legal challenges against the Electoral Amendment Act, the concerns about its constitutionality, and given the extension since June 2022, what are the merits put before the court on day one of the hearing?
Yes, I think that this is a significant case because it goes to the idea of equality before the law and equal treatment of everybody, which is part of Section 9 of the Bill of Rights, read with the entitlement to vote. And the new South Africa is really all about the right to vote. It's because people did not all enjoy the right to vote in the old South Africa that right was accorded to them, both in terms of the Bill of Rights and in terms of the legislation that followed for the holding of free and fair elections in the new South Africa. And initially, and certainly until the last election, the elections held at provincial and national level have always been according to a proportional representation scheme, and individual candidates were not entertained. That is not the case at municipal level, where individual candidates have been able to stand, and the challenge to that differentiation was upheld by the Constitutional Court in the litigation that was mounted a couple of years back. Parliament has not embraced the decision of the Constitutional Court wholeheartedly and seems to have done as little as possible to comply with the order made by Parliament, by the Constitutional Court, that Parliament should pass legislation that allows the independent candidates a fair shot. And the complaint at the moment is really that the independent candidates feel that they are not being given a fair shot, and that is what the arguments today is all revolves around.
Well, thank you for that context. I wonder, given the legal challenges now unfolding, what it could mean for prolonged levels of uncertainty, perhaps as we edge closer to elections. I'm wondering what the key considerations are at this point, given the timelines. Is there enough time? Will elections be free and fair at this point?
Yes, I've noted that the IEC has taken the point that it needs finality on this dispute as soon as possible, and hopefully sometime next month, because it is going to make a difference in many respects. The shape and size of the ballot form, the number of pages on the ballot form could change if the dispute is determined in a particular way. And even the size of the ballot boxes may have to be changed, and a whole lot of new ballot boxes ordered in order to make sure that the sanctity of the process is preserved when the election is fought on the revised basis that may or may not, depending on how the court approaches the arguments of the warring parties in court today, emerge as a consequence of this refinement. What we have at the moment is a system that seems to be a little bit prejudiced in favor of political parties and a little bit against the independent candidates. And one hopes that the Constitutional Court will find a way of resolving that is acceptable to all, and ensures that we do have a truly free and fair election in the course of 2024, that the IEC is able to administer in a way that it enables it to say at the end of the election proceedings that everybody got a fair shake, and that the result of the election has ensured freeness and fairness in the process.
No, absolutely, and that prep work is essential for the IEC. So that uncertainty, does cause a cloud hovering around it, the IEC and its prep work to date. Speaking of the judiciary, I want to shine a spotlight on it. How, if at all, is the mandate of the judiciary expanded with this legal challenge? In the same breath, when we look at the competency of the Constitutional Court to remedy electoral issues at large, what's being reflected here through the handing of this judgment, given the consequences for South Africa at large?
Yes, now the role of the Constitutional Court is to determine the dispute between the parties before it and those who are there to add light to all of the heat. And the Constitutional Court will be seeking to uphold the rights in the Bill of Rights that relate to the holding of free and fair elections in the new South Africa, elections in which for the first time at national and provincial level, it will be possible for the electorate, if they so choose, to turn their backs on political parties and to vote for independent candidates who are able to jump through the various administrative hoops that are being discussed in court today.
What are the possible solutions on the cards from your vantage point? Do we hold elections under the old election system? Will these reforms be time for independent candidates to be granted free and fair representation? What are you observing?
Yes, well, look, it is possible that the Constitutional Court will revise the system in such a way that it makes it impossible for the IEC to do its work in time for an election to be held next year. But it's also possible that a way through the woods can be devised that not only accommodates the complaints of the applicants in the matter, but also gives the IEC sufficient time to get its ducks in a row for a free and fair election in which individual independent candidates can compete with those who compete on party lists. It's not as though it's impossible. It's done at municipal level already.
Advocate Paul Hoffman, we're entertaining possibilities and probabilities at this point, testing the strength of our democracy. But really, what's set to unfold as we edge closer to 2024 elections? Thank you for your time with us on the SABC for those sentiments. Advocate Paul Hoffman weighing in. Of course, we know that the Independent Candidates Association of South Africa, One Movement South Africa, and Rivonia Circle have gone before the courts to have parts of the Electoral Amendment Act declared invalid and unconstitutional. We'll have to monitor developments and see what unfolds from there and too.